Thank you very much indeed, and congratulations. We've got to the end of the week. So I'm going to indulge us a little bit, if you don't mind. I'm going to ask you to do something for me. It has been an incredible experience this week, and I hope that you've had an enormously good time and will take away so much from the event. But for this to happen, there is an army, an absolute army of people who have made this happen, all the way from the Deputy Prime Minister's office into Her Royal Highness, who was here supporting, into our AV at the back, into our introducers here at the front, into the army of volunteers, the people who arrange flights, the people who've cooked your food, who've taken it away from you. We could not have this privileged and honoured experience without them. Now, I think this building is pretty stable. So what I'm going to ask you to do for a brief moment is to make as much noise as you possibly can so that it can be heard over in the Deputy Prime Minister's office to show just how much we appreciate how much everybody has done to make this such a success. What an honour and what a privilege, and it will stay with us all, I hope, forever. So feel free to shout, to stamp your feet, to clap your hands and to whistle. But please do let the Deputy Prime Minister know how much we appreciate it. Go for it. You are so wonderfully polite and reserved. If we had done that in Scotland, the roof would be falling down by now. This is an honour to be able to close this week. And if I'd known this was the role I was going to play, I probably wouldn't have chosen the subject I've done, because it's a bit of a downer. I would have chosen something a bit more upbeat and something that would have given us a few more laughs, but there's not an awful lot of laughs in what I'm going to do. It is, of course, the graveyard shift, so that of itself seemed to be appropriate that I would do that. I am a scientist and I'm an anatomist, a human anatomist at heart, and that is about the understanding the form and the function of the human body. And anatomy as a subject is a core subject. It's one of the oldest subjects because we're such a narcissistic set of primates that we like to look at ourselves and we like to look at others and we like to try and understand why we work. So it's no surprise that anatomy is right there back at the dawn of history of science. But what we do with anatomy is we try to apply it. And many people think anatomy is a dead and dying subject, no pun intended, but it isn't, because we can apply it. And these two words here are just the application of human anatomy. Forensic comes from the Latin word forensis, which means pertaining to the forum. And the forum were the courts and the open spaces of Rome. So anything that has the word forensic in front of it means that you are an expert for the court. It doesn't mean that you work for the police. It doesn't mean that you're an investigator. Your role is to the court. And because we're very traditional, we like a bit of Latin and then we like a little bit of Greek in there as well. So the anthropology bit just means that we study the human. So the summation of what we do is we analyze and we study the human, or what remains of the human, for medico-legal purposes. And what we mean by that is not all of our patients, like the one on the screen, are dead. Some of them are alive. And so I may be asked, for example, to assess the age of somebody who has come into one of our ports in the UK. They may have come across as a refugee or as an immigrant. They may have come across on the boats that I'm sure you've all heard about that we see on the English Channel. And when they arrive on UK soil, they may claim to be 17. Now, they might actually be 110, but they will claim to be 17, and there's a very good reason for that, because we signed up to the International Rights of the Child. And if you claim to be a child, then we have to treat you as a child. We have to keep you safe. We have to educate you. We have to feed you. We have to home you. And then the government will ask the question, is this person really a child? And wouldn't it be easy to be able to say, yeah, let's just make everybody a child and let you in? And you can't do that. And the reason you can't do that is A, because of the law, but B, because if you are a child, then we will place you into a secure institution for children. And if you're not a child, then we have placed an adult into that environment. And that means we have placed genuine children at risk. So it's really important for the safety of those who are genuine children that we are able to look at age estimation. So that's just one area where people are alive. Also, we will look at images, and we're going to do this later, but please don't worry about the images. There's nothing you're going to see that will cause you any concern. We're going to talk about the area of child sexual abuse, which is a global crime and one that is on the increase and increased substantially during the period of COVID. It's a global crime of enormous proportion, and it's going to require every scientist who ever just steps onto that threshold to help to try and play their part. But most of the time, then, unfortunately, where we are involved is in mass fatality events, in war crimes investigations, in situations where a body is found, where it's unexpected, and our job will always be to try to identify who that person was in life. And the reason we do that, if we can identify who they were, the chances are greater that we will find the person who's responsible for their death. But the other side of it is humanitarian. There is hopefully a family somewhere who misses that person. And until they know what has happened to them, they live with false hope. And whilst our job may be cruel at times, because the answers that we come with is that I'm sorry, this is your son or this is your daughter, it's an area of kindness, because what it does is it takes away false hope. False hope has no kindness. And it allows a family to accept the grief, to accept the dreadful situation that they find themselves in, and perhaps to be able to move forward. So that's the area in which I operate. This is the UK, well, it's the England and Wales judicial system. It's a mess. It's a complete and utter mess. It's an adversarial system, not an inquisitorial. And what we mean by an adversarial system is there are two sides in the courtroom. And when you're a witness in there, one side of that courtroom wants to prove to everyone that you are the world's leading expert in something. And the other side wants to prove you're an idiot. And one side will win. And you have little control over who wins on the day, because the courtroom is not the environment that belongs to the scientist. It belongs to the lawyer. We're only permitted to answer the questions that we're asked. We're not permitted to give free evidence. So at the end of the day, if they don't ask the right question, we're not able to give the narrative that we feel will help the case. Now, most of the time, I'm in this area on the left-hand side, perhaps down in the magistrates' court. And the magistrates' courts are fairly low-level crime, so we might not become involved in that. Up into the Crown Court, and Crown Court is where we will have juries and we will have trials for those individuals that, again, are in middle sort of level crimes, and we will go up into the High Court. And in the High Court is where we will have judges, we will have juries, and that's where the most serious crimes are going to be held. We tend not to get involved in tribunal courts, we tend not to get involved in family courts or county courts. Civil courts are really not for forensic scientists. But as you can see, if something goes wrong with your court case, you can end up in the Court of Appeal, and you can end up, of course, in the Supreme Court. Trust me, you don't want to get there, because if it's scary enough at the bottom, it's utterly terrifying once you get to the top of there. So that we are governed by the Ministry of Justice, and with the Home Office, and with the Attorney General's Office. But that's only in England and Wales. And the UK is a really complicated place because it's made up of a united kingdom. And in England and Wales, we have one judicial system. In Scotland, we have another one. And in Northern Ireland, we have another one. And so if you're an expert witness, you have to be able to understand the rules that are associated with giving your evidence in court, irrespective of which country within the union you are working. So you have to be a scientist who becomes aware of legal restrictions and legal constraints. And again, that's a very difficult place for a scientist, because it's an area, if we wanted to be lawyers, we'd have become lawyers. But if we place ourselves into the courtroom without that level of legal background knowledge, then we place ourselves very much at a disadvantage. So what is forensic science? And I bet you have an idea in your head what it is. And if I said to you, throw out some forensic sciences, you'd give me ballistics, and you'd give me DNA, and you'd give me fingerprints and blood spatter and all those sorts of things. It's nonsense. There is no such thing as forensic science. It's a myth. It's a myth that's been perpetrated by media and films and everything else, that there is this subject that is forensic science. There's two words in there. One of them's important and the other is almost irrelevant. The one that's important is science. But we all get terribly excited about the F word because forensic is really cool. No, it isn't. All the forensic means is you take your science into the courtroom. And the minute you walk from being a scientist in your lab into the courtroom, you become a forensic scientist. Whether you are a mathematician, a physicist, a chemist, a biologist, whatever it is, each and every one of you who is a scientist could become a forensic scientist. And that's the really important bit to remember. It is only about science that is going into the courtroom. And when you're called into the courtroom, it's because you're an expert in something, whatever it may be. It might be that you know how to tie knots. It might be that you know the viscosity of blood. It might be that as we head into the world of AI, as we've heard earlier, that level of expertise is required. So be very careful. You might be heading into court as an AI expert or a digital expert. And the reason that you're there is because you are allowed to have an opinion. And that places the expert witness in a really important place. That expert witness is the only person in the courtroom who is allowed to have an opinion. All the other witnesses are there because they've seen something, they've heard something, they know something that is directly relevant and admissible to that case that has been heard in court that day. The most important people in the room are the jury, and the jury are the members of the public. And most members of the public are not scientifically particularly literate. The last time they did science was when they were 17 years of age in school, and they haven't really kept up with it since. So therefore, we cannot expect the jury to understand what an algorithm is. We can't expect them to understand what AI is. But you know, every single one of those jury members thinks they're experts in forensic science because they've watched all those dreadful television programs that you've all watched, Bones and CSI and NCIS. They are entertainment. They are not reality. So we have a really difficult job with the jury. We have to persuade them to forget everything they think they know. Because the minute they say there's a forensic scientist on next, they go, oh, that's great, that's really exciting, I know everything about this. And we are the biggest disappointment to them on the planet because we want to talk about probability and Bayes' theorem and likelihood ratios. And the minute you mention statistics, you can see every single member of the jury glazing over because this is not what they had expected. That places an onerous responsibility on us. As scientists, we have to be really effective communicators because we have to be able to convey our scientific knowledge in a manner that will overcome preconceptions that they have because of the media, but will also help them to understand the importance of what it is that we're trying to say. Because ultimately, they have the most important job. They will decide on the guilt or the innocence of the person who's accused. They will be the ones who are responsible for whether they go to prison for a year or the rest of their life. And in a country where we have the death penalty, that jury is going to be responsible for the continuation of somebody's life. So taking our science into the courtroom is serious stuff. And when we take it into the courtroom, then we are going to put science on trial. How did it all start? I want to take you back to 1781 in Norfolk, which is in the east coast of England, to a tiny little village called Wells next the sea. And Wells next the sea was incredibly important in the 18th century because that part of Norfolk was creating huge swathes of grain that were being exported around the world. They developed a particular mechanism of arable farming that in Norfolk they were outstripping anybody else who was growing grain anywhere around the world. As a result, the ships needed to get into the harbour to be able to load and offload their cargo. And wells next to the sea, the harbour started to silt up. And as the harbour was silting up, the ships couldn't get in. And so they had to use little boats to be able to get out from the ships into the harbour. And the people who owned the boats and owned the businesses and the commissioners for the harbour were pretty cross. And they blamed the landowners, because the landowners had built encampments at either side, embankments at either side of the harbour. And they blamed the landowners for the river silting up. And they took the landowners to court. And the evidence that was given was a lot of local evidence, but there was also some scientists brought in who studied the harbour. And the scientists who studied the harbour said it's not about the embankment that's causing this. This is silt that's flowing down from elsewhere. There's an estuary to the north of here. And they were believed. And the locals were so utterly incensed that this incomer had swayed the jury at the time and they hadn't listened to the locals, that they appealed. And you saw that the appeal court is above. So they went to appeal. And then what happened was they decided, right, we actually need to bring in the men of science. And at this time they were all men, so it was the men of science. And they brought in this man. They brought in John Smeaton. And John Smeaton was an engineer. And he was somebody who was responsible for building harbours and for building lighthouses. And so he was considered a leading expert. He did the research. He published the papers. He was an academic as we recognize it by today's standard. But he had no knowledge of the local situation. But he came in on the appeal. And the defense team managed to get to a situation where they objected to his evidence, and he was never allowed to give evidence. So they went to appeal again. So you keep going back to appeal sometimes until you get the answer that you want. And what Smeaton was saying was, this is not about the embankment, this is about silt coming down from the River Ouse and the Humber estuary, and that's what's silting up the harbour. And he knew that because he could philosophize about it, which is why you have a PhD. You're a doctor of philosophy. You think about things, you theorize about things, you take knowledge that you know, you test it, and you decide. He was an academic. Not in the field necessarily that was directly related to wells next to the sea, but he was a scientist. And we went to Lord Mansfield. And Lord Mansfield was one of our great reformers of law. And he said, when it comes to matters of science, the only people who can rebut matters of science are other men of science. And he allowed Smeaton to give his evidence. And that was the first ever forensic expert witness in a courtroom anywhere. He was a forensic scientist, he was an engineer, not what you expect a forensic scientist to be. But that is the difference. We are allowed to go into court, having not been involved in that particular crime, but because of what we know, what we read from our literature, what we understand of our subject, what we've seen before in our experience, we are allowed to give opinion evidence. We cannot give an opinion on the matter in principle, which is whether somebody is guilty or innocent. That is the jury's job, and we must never usurp the jury. But our science and what we know about our science can go into the courtroom. And science doesn't say the same, as you well know. It changes. And as it changes, it becomes more and more challenging when a science is new and less well accepted for it to be allowed to get into the courtroom. There was the devil's own job to get DNA accepted into the courtroom in the 1980s, and now we don't even think about it. But we have a slight problem as well, because there's a gap between the scientist and the lawyers, and that's the police force and the investigative force. So the police force and the lawyers have a really strong relationship, and it's the police force that liaise with the scientists. So the scientists and the lawyers don't get to meet each other until we're in the courtroom. And as a result, in the courtroom, the understanding of science is often not well understood. The police don't understand it. The courtroom doesn't understand it. The police don't think they need to understand it because they've trusted the scientists. But your science is being tried, and you as a scientist in court. and losing that point of direct connection into the courts, which we used to have back in Smeaton's time and even into the 19th century, has now been taken away because of the introduction of police forces. So there is a barrier in between the law and the science, and that causes us problems. All of it comes back to the Magna Carta, right back in the 13th century. That's where it said in the UK we had the right to a trial by our peers. So that's where the jury comes in. Smeaton comes in really in the 1700s, in the 18th century. But we don't start to see the things that are forensic science until well into the 19th century. And I would argue that the very first science, if you discount the engineering, because that was really about the expert witness, the thing that we would consider to be recognized as science was toxicology. We had an absolute rife problem with poisoning, because we could go out and we could buy poison, arsenic in particular, from a chemist, because it kept down all the rats and the mice. And we suddenly found, you know, if you gave significant quantities of arsenic to somebody you wanted to get rid of, they had a rather nasty but a quick death. And if we gave them small amounts of poison but did it regularly, then, you know, it would mimic some of the diseases that were going around at the time, like cholera and food poisoning. So we might get away with a murder. Poisoning is a woman's choice of murder. We tend not to go for violence. We tend to go for something that is a little bit more subtle. But we didn't have a test for arsenic. So Marsh developed the arsenic test. And so we needed to be able to prove in the courtroom that we could detect arsenic in a person's body, in the tissues of their body, and perhaps in the food that they were eating. There's the first forensic science. After that came things like ballistics and fingerprints. Fingerprint comparison is not a science. All it is putting two images next to each other and doing that game that we used to play as children of spot the difference. How many of those points, those minutiae, match and how many don't? Then we'll look at the probability of that. That's where the science comes in. But actually fingerprint comparison itself is not a science. And we start to get all sorts of pseudosciences coming in. Things like graphology that say we can tell something about an individual by the way they write. Apparently, if your eye is directly straight, then you're an upright citizen. But if the eye as you write it is sloped to the left, oh, there's a sinister tendency in there. That was coming into the courtroom. It's nonsense. And pseudoscience has come into our courtroom for decades since. It's our job to ensure that these cowboys, who are the scientists, peddling their pseudoscience, are kept out of the courtroom, because the end product is so important. It's somebody's liberty and it's somebody's life. And we see when we have miscarriages of justice, people who are incarcerated for 17, 25 years, incorrectly on the basis of forensic science, is unacceptable. So that when we go into the courtroom, everything is tested. Your credibility as a scientist is tested. Is that really an appropriate level of degree? Goodness me, you got a third-class degree? Does that make you a suitable expert? That's what will be asked of you. You will be put under the spotlight as a scientist, because the job of the defense, because I'm usually prosecution, is to show that you are not worthy to have an expert opinion. I have seen a court case thrown out because a scientist did not note how many hours they had spent on a microscope, because they didn't keep proper records, processes, and procedures. And you never know when you might end up in a courtroom. Please stop using social media. Every defense lawyer will troll you online to find everything you've ever done, everything you've ever said, and they will raise it in court to show that you are not a credible and upstanding citizen. So that your world, if you go into forensic science, is on view for everybody. This is why I do what I do. A young teenage girl alleged that her father came into her bedroom at night and sexually abused her. She told her mother, and her mother didn't believe her. So what she did, incredibly brave young woman, was she left her camera running on her computer so that at night it would film her abuse. Can you imagine doing that? when your mother has said she doesn't believe you. What we see at 4 o'clock in the morning is a right hand and a forearm coming into view. That's all we ever see. And the police come to us and say, can we do anything with it? And I think, I have no idea. What can you do with an image like that? As anatomists, we know that if you shine near-infrared light onto human skin, live human skin, then you will be able to see the vein patterns underneath, because the near-infrared light interacts with deoxygenated blood, and it stands out like black tram lines. As an anatomist, I know that the V in veins stand for variable. And if you don't believe me, look at the back of your right hand and look at the back of your left hand. You've brought your own little Petri dish for the scientific experiment. I guarantee that the pattern of veins on the back of your right hand will be different to the pattern of veins on the back of your left hand. If your hands are a bit fat like mine, have a look at the inside of your wrists, and you can see it there. And go home and check it with your brothers, your sisters, your mum or your dad. It'll be entirely different, because that vein pattern is set down when you're a fetus inside your mum, and it rarely changes. So what I said to the police was, well, I can look at the comparison between Dad's veins and the perpetrator's veins. If they don't match, I can say with 100% certainty it's not him, because you don't grow new veins. But if they do match, I don't know what that means, because we have done no research at that level on variability in things like vein pattern. And the police said, no, have a go, because if at least we can exclude Dad, that's an important step forward. So there's the comparison between the perpetrator's veins and the Dad's veins. And unfortunately, for me, they matched. So I didn't know what that meant. And I thought that would be the end of it. But what happened was that the lawyers said, we're going to have a go. We're going to take this into court. That is not what you want as a scientist. And because you've done the work, you now can't say no. You have to go into court. And the judge called a voir dire. And what a voir dire is, they send the jury out and they decide whether they're going to let the evidence be admitted, because they want to know if there's a scientific basis to what we're saying or whether it's witchcraft. And what they do is they say, well, we understand the importance and the research behind anatomy, and we understand that vein patterns are, of course, now being extensively used in biometric security systems. So on the basis of that, we're going to hear the evidence, but you can't overstep your boundary, and that's really important. And it was the first time that vein pattern comparison was ever heard in a UK court. Dad was found not guilty. Who else was in her room at 4 o'clock in the morning doing what she said her father was doing to her? It's not my job to ask that question, because the jury have found him not guilty. But what I was sufficiently incensed with was that science at that point had not been far enough advanced for me to be able to answer the question, how likely is it for this pattern to exist? So I happened to have 500 police officers going through my department at the time, so I stripped them all to their underwear, and which they all did very willingly, and allowed me to photograph in visible light and near-infrared light the pattern of veins and other anatomy on their hands, their forearms, their arms, their feet, their legs, and their thighs. We didn't go anywhere else. And it allowed us to create a database, and we could start looking. And the things that you see, for example, are my vein patterns under near-infrared light, which are in dotted lines on this side. The blue circles are my freckles, because we have punctate pigmentation. I'm a redhead, I have freckles. The white squares are because I'm a really bad anatomist. Those are my scars. That's where the scalpels nicked my hand. We look at the lineals at the base of the fingers. We look in the ovals at the pattern of skin creases on your knuckles. And I guarantee if you look at the pattern of skin creases on your knuckles, they will be different in every finger and different across both of your hands. And even wearing of jewelry, you can see that we do that. And we created cladograms that showed within our database how many hands would have the same pattern of each of these features. But it's just so time-consuming, and it's not something that we can follow through. But this is the enormity of what we're seeing in courtroom. We're doing one of these cases a week. Now, that might not sound much, but this is really the sort of top of an iceberg. 82% of the cases that we now give a report on end up with a change of plea. That's a hugely powerful statistic. Now, people change their plea to guilty for a number of reasons, but it's a change of plea. And it means that young people don't have to go into court anymore and give evidence against their father, their mother's boyfriend, or whoever it might be. It's very much a protecting for young people. But that doesn't mean that we're actually moving things forward. Because what we realized within the hand, what we had was a multimodal biometric. So many pieces of anatomical information that we could bring together to be able to give us a much stronger likelihood. And then we had that magic moment when somebody said, well, we need to be looking at AI. We need to be looking at computers who can do this kind of work for us. I'm an anatomist. I didn't even know what AI meant, let alone anything else. So I have to bring a team together, people who've got the expertise that I don't have. We were very lucky. Europe gave us a very good research grant to be able to look at this. What we did was we created the world's largest database of hands. Images coming in from mobile phones, images that we have taken, and three-dimensional scanning images that we're using for a very different purpose. And we were able to start looking at what is ground truth. So as the scientists, we could say this is the vein pattern. We can train the computer to identify that vein pattern. And we wanted to be able to do that for every single part of the anatomical features we were looking at. But our problem with our algorithms is we can't have black box, so that the courts will not allow us to give evidence that we can't prove how that came about. So everything we do has to be white box. We're now in a position where we're able to localize features. So we have a system whereby through computers it will identify in these videos, because trust me, we don't want to watch these videos, where we can identify the hand and we can extract the images and the stills of the hand in that video. We have programs that allow us to identify the areas of the hand for which we want to extract information. We're able to show how many of those different areas of the hand we need to get to until there is no longer any other individual in our database that matches that. And we're able to create these thresholds, other cladograms that are able to show how many steps do we need to go through, how many features do we need to follow before we get to a level of the highest probability that the suspect is the same individual. And we do it for vein patterns. So we've trained the computers how to be able to find the veins. And we're now training them how to be able to find the nodes, which are the points where it separates, and where the endpoints are. So we now are in a system where we can find the hand in the video, we can extract it, we can find each of the anatomical features, we can extract that, we can create the multimodal biometric, and we can then run those through databases now to see if there are any other individuals who hold the same hands that we in fact have found in our images. Initially, we were working to a probability of match of about 1 in 10,000. It's frightening what the large data sets and AI are now telling us, that we may be in a position, not yet, of getting to something in the region of 1 in a billion, because the variability in the hand, which the anatomists have known since the times of Vesalius in the 1500s, we know is coming to reality. Getting that into our courtroom is difficult. And it's a long, long way from getting AI into our courts. This is the last case that I've just done. Now, this individual, the jury found guilty. He's been given 15 years in jail. He pleads his innocence. It is not my job to decide if he's guilty or innocent. It's my job to use my science and to use my expert witness to be able to allow the jury to do that. What we do know, though, is that technology is really catching up with us. And in fact, we're seeing some commercial companies looking at the hands as that biometric, both the palmar surface and the dorsal surface, because there are so many features in it, that maybe now we no longer need our phones to be able to pay to go on the subway. Maybe actually our hand is all we need, because it carries more information about our identity than almost anything else. And one could argue possibly more information than some aspects of DNA, because in DNA, as we look at it in forensic sense, we only ever look at 17 to 25 different loci. We don't look at the whole genome. Then, in fact, we're probably going to get to a point of being more reliable. So all I wanted to do is to leave you with the idea that whilst the science that you do, you may feel it's so far removed from the courtroom, it might not be, because you might be that scientist who is called into the courtroom. If you are, my advice is make sure you understand the law before you go in. Make sure you really understand your science, because the lawyer's job is to test you and to test your science. And it is an alien world, is a gladiatorial world. And if your reputation matters to you, and let's face it, it does matter to most scientists, then the courtroom is not for you. Because their job, the alternative, the opposing side of counsel, is to prove that you have no reputation. And every single time you go into the courtroom, the thing you risk, the risk is to the accused, but the thing that you risk is your reputation as a scientist. It's a really scary place, and nothing like the television. Thank you very much.
Thank you so much, Professor Dame Sue. And now let's invite Dr. Sarah on stage to moderate the Q&A. And once again, participants, if you have any questions, please introduce your name and your institution before saying your question. Thank you.
Hello, everyone. I'm Sarah. And that was an extremely fascinating, incredible talk, which took us through the courtrooms. And now I have a deep fear of taking my science into the courtroom. And I see already there are a couple of people lined up for questions. So without further ado, please go ahead.
Hi, good afternoon. I'm Revati. I'm from the University of Illinois, Urbana-Champaign. First of all, I want to thank you for your extremely meaningful and selfless work. And when I was listening to you, what I kept thinking in my head was, what would I do if I was in your position? And I was wondering, how do you make sure that you don't get emotional when you are doing this whole work? Because like you said, it has a lot of huge consequences and a huge sense of responsibilities involved. How do you remain rational in those situations and keep yourself in balance?
It's a very good question, and thank you very much indeed for it. The world that I operate in, which is mass fatalities, war crimes, child abuse, they don't get much worse than that. They really don't get much worse than that. When I started the work into the child sexual abuse, I spoke to a very dear friend of mine who's a police officer, and his advice to me was, just don't do it. His advice was, because those images will get inside your head, and one of those days those images will bite you. And he said, but I know that you're a middle-aged, red-headed, irascible Celtic woman. You're going to do what you want to do anyway. So I'm going to give you another bit of advice. And the bit of advice he gave me was to say, don't own the guilt. You didn't cause this. You couldn't have stopped this. This is not your business. You have no right to be outraged by it. You have no right to want to find somebody guilty. That's not your job. Your job is to be an impartial scientist. You go into the work, you find the evidence, you retrieve it, you analyze it, you present it, and you go home. And they say, if you can, find a clinical box inside your head and open the door and go to work and close the door behind you so that your world is behind you and you're in the box. And when you leave work, open the door again, but remember to close it behind you. My fear is that sometimes that door might not just close properly and you could bleed over from one world into the other, and that's where you get post-traumatic stress. So I'm not so arrogant as to say it will never happen, but it hasn't happened yet. A very dear colleague of mine who is a forensic pathologist who has done thousands of postmortems, he heard an ice cube dropping in a glass in a bar. And he said, I could feel myself going into a spiral. It brought him back to the Bali bombings, to the rows of bodies packed in ice, and he went down into a depression that he couldn't get out of. So we all know it can happen to us. I have a wingman, and she is my buddy system, and she's known me for 25 years, and I've known her for 25 years. And we are brutally honest with each other, and we speak to each other at least once a week. If she saw a change in me, she would report me for counselling. If I saw it in her, I would report her for counselling. So we're absolutely brutal, total faith and trust in each other, because you have to accept that we are just human, and you never know when there might be one case that is the one that will undo you.
Thank you so much, Prof.
Thank you.
Hi, it's Aaron from the Australian National University. Thanks for the great talk on this this work. It's very important and very impressive. I have kind of a technical question about the...
Oh gosh, I'm not very good at technical.
Okay.
That's why I have a team. I have a really
Semi-technical?
mean research team, in that what they do is that they hold a bet on how long it will take in a meeting that I am with them that I no longer understand what they're saying. And the last time we had a board meeting, it was slide number 2. So if it's terribly technical, I might not be able to help you.
I don't think it's terribly technical. 'Cause
Okay.
I do physics, so I don't know anything about biology anyway. When I go rock climbing, my fingerprint doesn't work on the reader anymore, just from the fact that it gets quite damaged and it takes a few days and then it works again. I was just wondering, with the variability in the hand, do you have to account for when people are working in particular jobs where they're exposed to lacerations or damage, skin cancer, etc.? Or is it less variable than you might think?
That's a question I can answer, so thank you very much indeed. So that we have to build in variability. There are some things that don't change. Vein pattern doesn't change unless you have sclerotherapy, which is surgery to remove the vein. They might get a bit more tortuous, but the way in which they branch and where they branch doesn't change. But fingerprints, you're absolutely right. We lose them with age, so that when you try to take fingerprints, for example, from some elderly, then it's very difficult. Not because the print is there, but because there's less sweat on the fingerprints and the hands tend to be drier. And yours, what you're doing is you're wearing away the epidermal layer of the skin, and the dermal layer underneath is the one that produces the print, which is why it comes back a few days later. So that we have to be able to make an account for change. So that we might have a set of images from an offender that were taken, say, 2 years ago. And now we have a set of images from the suspect 2 years later. What could have changed? Scars could have occurred, diseases could have occurred or been healed. Like you, fingerprints could change. They might have had a tattoo done. They might now wear jewelry that they didn't. So we have to be able to account for the reasonable. And then when you've accounted for the reasonable, everything else that's left is evidential. So it's a very good question. Thank you.
Thank you.
Thank you. Why don't we go to this lady over here?
Oh, I think you stood in line before me. That's fine. Yeah, go.
So very polite. Okay, go ahead.
Thank you so much. I'm Miguel from Nanyang Technological University in Singapore. I was very intrigued by a couple of slides you showed. So I totally agree that in some cases like policymaking and forensics, right, we cannot afford working with black boxes. Yeah. I do agree on that. At the beginning of your talk, you also mentioned the base rule, right?
Sorry?
The base rule, which is a device that different to classic paradigms of doing statistics, right? Apart from data, includes information, right? To produce conclusions, basically, right? And as a Bayesian statistician myself, I want to challenge myself too, and say private information can be induced, right, in order to produce some desirable result, right? Let's say now we go to the classic paradigm and we are only based on data, right? We can sort of invent different type of metrics to produce the evaluation of our models, right? So that, again, we can get a favorable results that might lead us to use one particular model to judge how well we are performing at, in this case, evaluating evidences, right? So I'm very curious to know under which standards the technical models are chosen, because it is very hard to think that subjectivity, that we can avoid subjectivity basically in anything we do, right? Even if we go with classical statistics or Bayesian statistics or even black boxes methods.
So bearing in mind that everything we do in the courtroom is based on a subjectivity because it's based on an opinion. The importance is the opinion is based on fact that is as verifiable and as accurate and as repeatable as possible. So fundamentally, we're always going to come back to a subjective opinion, but based on data. So we must be able to trust the data. Some of the data that we have and that we use in the forensic world is very small, very, very small databases. And it worries the living daylights out of me that we base an opinion sometimes on very small data. Or we base an opinion on a particular individual who has a real drive that this is going to be the next best thing. The classic thing was ear prints. So for quite some time, ear prints were the new kid on the block. And the basis was if somebody was going to break into a house, you'd put your ear up against the door or up against the window and you'd leave that print behind. And there was one particular expert who was determined to make sure that this got into every courtroom in the land. But of course, the data supporting it was so weak that once it was shown to be weak, the entire area fell apart and is never used in the courtroom now at all. So there's a risk on the science that says if you're too enthusiastic and you're too much of an entrepreneur that's desperate to get your product out there before anybody else, you could lose it all. It is about making sure that there's a good scientific foundation, that any models that you use are models that other people approve of. So we have to get it out into the academic literature where others are saying, yes, this is the right one to do, or they're producing an alternative model, then we all need to test it to see which one is the best. Because ultimately, all we're trying to get to at the end of the day is the greatest degree of confidence we can have in the data and in the research we've done to form our opinion. But if we're careless about the model we choose or why we choose a particular model, then the result of that is catastrophic, so that the pressure is on us to do it. But there is nothing in legislation that says you must do it this way. It is left to our discretion because we are the men of science, and the men of science are the only ones who are answerable to the men of science. So we have to moderate ourselves. And when we find something in the literature, in the models, or whatever it may be, that we feel is not correct, we have to call it out. And of course, as a result, everybody hates you if you do that because you've just rubbished their theory. But at the end of it, it's too important for it to be about the ego of a particular scientist or their laboratory. It's about people's freedom.
I have a quick, very follow-up question, if you allow me.
I think we should move on to the
Come and speak to me later.
Yeah, we can take the questions offline.
Thank you.
Go ahead, please.
My name is Sigrid. I'm from Uppsala University in Sweden. First of all, thank you for this presentation and for your very important work. Listening to this, I immediately think about Gisèle Pellicot in France, whose husband filmed all of her assaults. And I'm interested in how you think this can be applied to other crimes that are not sexual assault, and how your arms and your hand can be identified, or what do you think is the future of this? Can this take over fingerprints, for example, in the future, or other fields where you think this is not to any help at all?
Thank you, and I'll do the second bit first before I do the first bit. What we don't want is to remove any techniques from the toolbox, because you never know what the case is going to come to you with in terms of evidence. So you need to have a range of tools. If all you have in your toolbox are screwdrivers, when you need a hammer, it doesn't work. So we need to make sure we have all the tools and that we use the most appropriate one depending on the circumstances of the particular case. So we don't want to remove fingerprints. We want to augment what is already going on. Some of the cases that we've worked on, for example, not just in child sexual abuse, but also involved in, for example, individuals who are drug running will want to be able to show and be able to prove to the snakeheads, to those who are running the drugs, that they have handed the drugs literally over to somebody else. So we get great views of thumbs and such things in those sorts of images. So anywhere that we have an image of a body part, then we can do a comparison. I'm going to lower the tone slightly, if I may, is that in these sorts of images, various parts of your body may be in the image. And an indecent image of a naked gentleman was sent to a young woman. And the police traced it back, found the phone, and arrested the individual because that indecent image had come from his phone. The individual said, yes, it was my phone. No, I didn't send it. And that isn't my penis. So the question from the police is, could I compare? I'm sorry, but I'm an old woman. I don't want to do this. But we had to compare a part of the body that we had never had to compare before. And I'd said, okay, we can have a go, but I feel I'm right back on day one again. We don't have data on this. We do now, but we didn't then. And welcome to my world. It's just anatomy. And at the end of the day, the individual whose phone it was had a particular venous pattern on the dorsal surface of his penis that is the most common pattern. 95% of men have it. The individual on the image had a different pattern that only 4% of the population have. So I could say it was not him. Can you imagine the embarrassment of having to stand in the courtroom facing this poor young man, and he knows what you've seen and what you're commenting on? But the bottom line is you may not have committed the crime, but do not let other people use your mobile phone, because they may take photographs of themselves and send it to other people, and you may not be as lucky next time. So you never know where these crimes are going to come in. It might be in drugs, it might be in indecent images, it might be in sexual abuse. Sometimes we also see it in relation to in a bank, not that there are very many banks these days. When you pass things across the bank, you get a beautiful view from the camera of the back of the hand. Is it the same individual? Anywhere that a hand occurs.
Thank you.
You're welcome.
All right, I'm so sorry, but I think we have reached the time.
Sorry, I talked too much. I do
No,
apologize.
you are welcome to approach
Please.
Prof Sue afterwards when there's a break. So together, I'd like to thank Prof Sue for a very thought-provoking, very interesting, very fascinating, and of course, extremely impactful talk and career. Thank you so much.
And thank you.